Hi, and welcome to Law Now. Imagine one day you wake up in a world where your most basic freedoms could be stripped away from you at any moment. A world where the government could silence your voice, restrict your movement, or deny your dignity without any consequence. This was the reality for most of human history until a revolutionary idea began to take shape in the human mind: the concept of fundamental rights. Think of fundamental rights as the terms and conditions of citizenship, except these actually protect you and are way more interesting than that scrolling text that you never read. Today, you will get an introduction to fundamental rights as enshrined in the Constitution from Articles 12 to 35. This video will equip you with a deeper understanding of each of the fundamental rights so that it is easy for you to navigate legal problems, and it will be good for your future legal practice, and you will start appreciating the powers that our great Constitution grants to every citizen of the country. I will cover each of the fundamental rights separately in more detail in the coming videos. This is part 5 of the series on constitutional law. Previous parts are linked in the description. And don't forget to hit the subscribe button to stay updated with future videos. I hope that you're ready to take some notes because this will help you retain the information that you learned today. Now sit back, focus, and let me boost your legal IQ. Our story begins in the 17th century with philosophers who dared to ask radical questions. Like, what if humans are born with rights that are inherent, universal, and sacred? John Locke, a philosopher ahead of his time, believed that every person is born with something extraordinary. And no, he wasn't talking about a soul, but a title to perfect freedom. He argued that humans have a natural power to protect their most precious possessions: life, liberty, and property, as fundamental rights that exist prior to and independent of any governmental authority. Picture the world of those times. Monarchs and rulers wielded absolute power. Your rights were whatever the ruler decided they would be. Then came thinkers like Locke and Rousseau, who proposed a revolutionary concept that rights aren't granted by governments, but they are inherent to human existence. The French Revolution in 1789 became the first massive political expression of this idea. Their declaration was bold and simple. The aim of all political association is the conservation of the natural and inalienable rights of man. But how do you protect these rights? How do you ensure that they can't be taken away by the whims of a political majority? The United States Constitution provided the first modern answer. In 1791, they added the Bill of Rights, 10 amendments that would change the future of America forever. These were not just acts, but they were a promise that certain freedoms are so fundamental that they stand above political debate. As the world evolved, this idea spread. Then came the United Nations Universal Declaration of Human Rights, proclaiming that recognition of human dignity and equal rights is the very foundation of freedom, justice, and peace. But fundamental rights are not just beautiful words on a paper. They act as a shield, a protection against the potential tyranny of state power. Think of fundamental rights as a constitutional firewall. They ensure that your freedom of speech cannot be silenced by any political pressure, your right to equality cannot be compromised by discriminatory laws, and that your personal liberty cannot be arbitrarily restricted. These rights have a unique power. They can only be modified through a formal constitutional amendment, not by simple legislative tricks or temporary political majorities. They serve a dual purpose. First, they give citizens the power to challenge governmental actions in court. Second, they place clear limitations on what governments can do, which is important for any democracy to thrive. From the streets of Paris to the halls of the United States, from civil movements to landmark court judgments, fundamental rights have been the cornerstone of human dignity. Today, when we speak of fundamental rights, we are not just discussing legal provisions. We are continuing a centuries old conversation about freedom, dignity, and the relationship between the individual and the state. Fundamental rights remind us of a profound truth that before we are subjects of a state, we are human beings. And our humanity comes with certain inalienable and non negotiable freedoms that no one can take away from us. To truly understand fundamental rights in India, we must first appreciate their philosophical underpinnings. During the Constituent Assembly debates, Sir Aladi Krishnaswamy Iyer eloquently observed, "The chapter on fundamental rights in a constitution is the most criticized portion in any constitution. The reconciliation of individual liberty with public good is a most difficult task. This tension between individual freedom and collective welfare defines the unique character of Indian fundamental rights." While inspired by the American Bill of Rights and influenced by the Universal Declaration of Human Rights, our fundamental rights reflect distinctly Indian values and historical experiences, as noted by Justice Krishna Iyer in his characteristic poetic style. Our Constitution is not a marketplace charter, but is a magnificent basic document which blends individual freedoms with social justice and political democracy with economic democracy. Part 3 of our Constitution organizes fundamental rights into six comprehensive categories. Right to equality from Article 14 to 18. This right ensures legal equality and prohibits discrimination based on religion, race, caste, sex, or birth. Right to freedom. Articles 19 to 22. This right protects essential freedoms like speech, assembly, movement, and profession, while preventing arbitrary arrests. Right against exploitation. Article 23 and 24. These ban human trafficking, forced labor, and child labor, ensuring human dignity and fair treatment. Right to freedom of religion, Article 25 to 28. These guarantee freedom to practice and propagate religion while maintaining secular principles. Cultural and educational rights. These come under Article 29 to 30. They protect minorities' rights to preserve their culture and establish educational institutions. The right to constitutional remedies. Article 32. This right is the soul of the Constitution according to B.R. Ambedkar, as it allows citizens to approach the Supreme Court directly if any of the above fundamental rights are violated. When you fully grasp these rights and the power they wield, you'll unlock a profound sense of empowerment and responsibility. Dr. Ambedkar once said, "What are we having this liberty for? We are having this liberty in order to reform our social system, which is full of inequality, discrimination, and other things, which conflict with our fundamental rights." So these rights are not only there to protect us, but are also there to eliminate social wrongs from society, to make it a better place for us all. Then we come to Article 13, which serves as the guardian of these rights, declaring that any law contradicting fundamental rights shall be void. Professor M.P. Jain, in his authoritative treatise on the Indian constitutional law, explains Article 13 gives teeth to the fundamental rights. Without such a provision, fundamental rights would remain mere paper declarations without any legal force. Unlike many other constitutions, our fundamental rights aren't absolute. Most contain carefully calibrated, reasonable restrictions that balance individual liberty with social needs. This balance is also important for what the Constitution aims to achieve. Let's begin our exploration with the bedrock principle of equality. Article 14 guarantees equality before law and equal protection of laws to all persons, not just citizens, within the Indian territory. There are two kinds of people in any country: citizens and aliens. I have explained in detail the difference between them in the video on citizenship. In order to better understand the whole constitution, I will advise you to go through the video lecture series from the beginning. The link to the playlist of the full series is in the description. Now let us continue with Article 14. In the landmark case of E.P. Royappa versus State of Tamil Nadu 1974, Justice Bhagwati revolutionized our thinking of equality with these profound words. Equality is a dynamic concept with many aspects and dimensions, and it cannot be imprisoned within traditional and doctrinaire limits. From a positivistic point of view, equality is antithetic to arbitrariness. This judgment transformed Article 14 from a narrow mathematical concept of treating equals equally into a powerful protection against arbitrary state action. Later, in Maneka Gandhi versus Union of India 1978, The court further expanded this understanding with Justice Bhagwati noting Article 14 strikes at arbitrariness in state action and ensures fairness and equality of treatment. The principles that were established in Maneka Gandhi versus Union of India continue to exert a significant influence on cases involving Article 14 of the Indian Constitution even today. The core tenets of reasonableness and non arbitrariness in state action, as emphasized in Maneka Gandhi, serve as a benchmark for evaluating the fairness and legality of governmental measures. Articles 15 to 18 elaborate specific dimensions of equality. Article 15 prohibits discrimination on the grounds of religion, race, caste, sex, or place of birth. Article 16 ensures equality of opportunity in public employment. Article 17 abolishes untouchability. Article 18 abolishes titles except military and academic distinctions. The Indira Sahani versus Union of India case 1992 represents perhaps the most consequential interpretation of these provisions. The court upheld reservations for socially and educationally backward classes while establishing the concept of the creamy layer and the 50% ceiling on these reservations. As Justice Jeevan Reddy observed, the object of reservation is to remove inequality, to remove imbalances in public employment, and to bring backward classes into the mainstream. This decision of the Supreme Court led the Parliament to pass the 77th Amendment in 1995. And by this amendment, the decision of the court was made ineffective by insertion of Clause 4A into the Article 161. This is an enabling clause, empowering the state to make provisions for reservation in the matters of promotion for scheduled caste and scheduled tribes. Article 19 to 22 enshrines our essential freedoms, what Justice Hidayatullah called the pillars of liberty. Article 19.1 guarantees 6 fundamental freedoms to all citizens: freedom of speech and expression, freedom of assembly, freedom of association, freedom of movement, freedom of residence, freedom of profession. In Ramesh Thapar versus State of Madras 1950, one of the earliest freedom of speech cases, Chief Justice Patanjali Shastri emphasized freedom of speech and of press lay at the foundation of all democratic organizations. For without free political discussion, no public education, so essential for the proper functioning of the processes of popular government, is possible. This case is important because it affirms that freedom of speech and press are vital for democracy. And this case was fought because the government had banned a journal infringing on these rights. More recently, in Shreya Singhal versus Union of India 2015, Justice Nariman struck down Section 66A of the Information Technology Act, reaffirming the right of free speech and expression includes the right to receive and impart information. It includes the right to communicate and circulate one's opinion, views, ideas, knowledge, information by words of mouth, writing, printing, pictures, or any other mode. Before this judgment, the Section 66A of the Information Technology Act was used to arrest many people just for posting their views online. Articles 20 to 22 provide crucial protections against arbitrary detention and punishment. Article 20 protects against retroactive criminalization, double jeopardy, and self-incrimination. These terms are pretty self-evident, but I will go in detail into each of them in the coming videos. Article 21 guarantees the right to life and personal liberty. Article 22 provides safeguards against arbitrary arrest and detention. Maneka Gandhi versus Union of India 1978. This case transformed our understanding of Article 21, with Justice Bhagwati declaring the procedure contemplated by Article 21 must be right, just, and fair, and not arbitrary, fanciful, or oppressive. This shifted the interpretation from mere procedure established by law to substantive due process, which means that Article 21 of the Constitution, guaranteeing the right to life and personal liberty, is no longer limited to simply following legal procedures set by the government, but now requires that the procedure itself as well as the law authorizing it, must be fair, just, and reasonable. This dramatically expanded the constitutional protections and made sure that the procedures established by law are right, just, and fair. Articles 23 and 24 prohibit human trafficking, forced labor, and child labor, recognizing that true freedom requires protection from exploitation. In People's Union for Democratic Rights versus Union of India, 1982, Justice Bhagwati expanded Article 23's scope, where a person provides labor or service to another for remuneration which is less than the minimum wage. The labor or service provided by him clearly falls within the scope of the words forced labor. Article 24 prohibits employment of children below the age of 14 in factories, mines, or any hazardous employment conditions. In MC Mehta versus State of Tamil Nadu 1996, Justice Kuldeep Singh ordered comprehensive measures to rehabilitate children workers in hazardous industries, noting that children are the nation's most valuable human resource and cannot be treated as articles of commerce. Article 25 to 30 protect religious freedoms and cultural rights, which is essential in our diverse and pluralistic society. Article 25 guarantees freedom of conscience and free profession, practice, and propagation of religion. In the landmark judgment, Indian Young Lawyers Association versus State of Kerala 2018, the Sabrimala entry case, Justice Chandrachud emphasized religion cannot be used as a cover to deny rights of worship to women. To treat women as lesser beings based on biological or physiological features denies them constitutional morality. Articles 29 and 30 protect the interest of minorities by safeguarding their language, script, culture, and educational institutions. In St. Xavier's College versus State of Gujarat 1974, Chief Justice Ray observed the whole object of conferring the right on minorities under Article 30 is to ensure that there will be equality between majority and the minority. If the minority institutions are made carbon copies of the state institutions, the minority character will be lost. And finally, we come to Article 32, what Dr. Ambedkar called the heart and soul of the Constitution. This article guarantees the right to constitutional remedies through writs. In the Constituent Assembly, Dr. Ambedkar passionately argued, if I was asked to name any particular article in this Constitution as the most important, an article without which this Constitution would be a nullity, I could not refer to any other article except this one. It is the very soul of the Constitution and the very heart of it. In Premchand Garg versus Excise Commissioner 1963, Justice Gajendra Gadkar affirmed the fundamental right to move this court can be appropriately described as the cornerstone of the democratic edifice raised by the Constitution. Later, in L. Chandrakumar versus Union of India 1997, the court declared that the power of judicial review under Articles 32 and 226 is part of the basic structure of the Constitution and cannot be abrogated even by constitutional amendments. Over the decades, judicial interpretation has dramatically expanded the scope of fundamental rights, particularly Article 21. Through creative interpretation, the Supreme Court has recognized numerous unenumerated rights, including right to privacy, interpreted through Justice K.S. Puttaswamy versus Union of India 2017, right to clean environment, recognized in Subhash Kumar versus State of Bihar 1991, the right to education, recognized in Unni Krishnan versus State of Andhra Pradesh 1993. Right to health, recognized in Paschim Banga Khet Mazdoor Samiti versus State of West Bengal 1996. Right to die with dignity was recognized in Common Cause versus Union of India 2018. In the historic privacy judgment, Justice Chandrachud eloquently articulated, privacy is the constitutional core of human dignity. Privacy includes, at its core, the preservation of personal intimacies, the sanctity of family life, marriage, procreation, the home, and sexual orientation. Privacy safeguards individuals' autonomy and recognizes the ability of the individual to control vital aspects of his or her life. Despite their fundamental nature, these rights are not absolute. Article 19 explicitly permits reasonable restrictions on grounds like security of state, public order, and morality. In Modern Dental College versus State of Madhya Pradesh 2016, Justice Bobde articulated the doctrine of proportionality. He stated, a limitation of a constitutional right will be constitutionally permissible if 1. It is designated for a proper purpose, 2. The measures undertaken to effectuate such a limitation are rationally connected to the fulfillment of that purpose. Number 3. The measures undertaken are necessary. Number 4. The burden imposed is proportionate to the benefits. Additionally, fundamental rights can be temporarily suspended during emergencies, a provision that was unfortunately tested during the 1975 to 77 emergency. As we conclude our introduction to fundamental rights, remember that these are not mere legal abstractions, but living guarantees that touch every aspect of our lives. Professor Upendra Bakshi, one of India's foremost constitutional scholars, reminds us the Constitution is not merely a legal document, but a chronicle of hopes and aspirations, a testament of faith in social regeneration, and above all, a covenant of dignity and equality of all human beings. In our next episode, we'll delve deeper into the right to equality, exploring how concepts like reasonable classification and arbitrariness have evolved through landmark judgments. I have prepared questions and answers related to this topic, which are on my blog. You can find the link in the description. In case you have any questions or you want me to cover some specific topics that you find hard to understand, you can let me know in the comment section. Thank you for watching. See you next time.